Hello, and welcome everyone. Thank you for joining today's webinar dedicated to the European Health Data Space Act. I will wait 30 seconds more for everybody to join. We already have 25 participants, but we are waiting for more people. Okay, shall I start? What do you think? Yes? Hello everyone, my name is Nathalie Poupard. I am counsel in the tech and data team at Phil Fisher's Brussels office. I'm delighted to be joined by two of my colleagues today, Nuria Pastor, she's director at our London office, and Katharina Weimer, partner at our Munich office. This session is being recorded and will be made available on our YouTube channel. If you have any question during the presentation, please feel free to submit them via the Q&A box. We'll do our best to address them during the session or at the end of the session. For your information, there will be a second webinar in September dedicated to EHDS and more particularly to the secondary use under EHDS. I will provide you the full information on this in the chat box. So this session is designed to break down the key elements of EHDS and to explore basically what it means for stakeholders across the EU health ecosystems. So from healthcare providers, researchers, to digital health innovators and policymakers. We have listed here for you what we think are the most frequently questioned currently about EHDS, and we will try to answer them in this webinar. So this is regarding the scope, the governance, the timeline, the possible sanctions, and also very practically concerning EHDS, what does it do, who does it apply to, why is it relevant to you, how this may in fact affect your business, and so forth. So the EHDS is not just another regulation. It's actually the first legislative initiative to come from the European Strategy for Data, which is actually the broader, I would say, European vision that was launched back in 2020 to create a single market for data. So that was really the first goal of EHDS. And I would say that EHDS represents a major step forward in this EU digital health strategy. It was officially published on the 5th of March of this year, and it entered into force 20 days later, so on the 25th of March. So what is the EHDS aiming to achieve? I think that's the question. Well, the EHDS wishes to empower really all EU citizens with regard to their medical record, so to allow citizens to access, control, and share their electronic health data across the border within the EU. So that's, I would say, the first goal. Currently, health data governance quite varies widely across member states. It's really different in all the member states. So EHDS will introduce a common legal and technical framework to ensure that data can be exchanged securely and efficiently cross-border in Europe. So this is really a goal of harmonization, I would say. Then EHDS will also create a single market for electronic health record systems. So this is also new from EHDS. By setting interoperability standards, the EHDS will support the development of a unified market for health record system. So this basically will reduce the fragmentation. And then we are also talking about secondary use of data. So beyond this individual care, health data, has also so much value for research and innovation, public health, and policy making. And that's why EHDS establishes clear rules for the reuse of data. This is what we call secondary use of data. And finally, last but not least, I would say the EHDS is also bringing the foundation for more governance around this topic. So this includes the creation of new EU level bodies. I will explain this in a bit, but also national health data access body to oversee compliance and manage access requests. So let's talk about how the EHDS is going to be managed. Well, first, the EHDS sets up a new advisory and regulatory group that is called EHDS Board. It's a bit comparable to other European regulation. So you can think of this as a central team that helps EU countries and the European Commission to work together on health data. The board will play a big role in shaping how things are done. For example, when it comes to secondary use of health data, the board will help countries to align how they can manage those access to health data, share their best practices, and also flag any risk or issue that might come up. Each EU country has a chance to send two representatives to this board. One will focus on primary use and the other one on secondary use. The board will be co-led by someone from the European Commission and someone from the member states. And they can also bring in outside experts when needed. Now, to make sure that the real world voice will also be heard, the EHDS also creates a stakeholder forum. This is where people from different sectors can give feedback and share their views. So this might be, for instance, doctors, researchers, patients, and so forth. Also, I would say a representative of the pharmaceutical industry. The goal here is to balance, I would say, both commercial and non-commercial interests. The member of this forum will be chosen by the European Commission through an open application process. And finally, there are also steering groups that handle the day-to-day operation of EHDS infrastructure. That is called My Health at EU. This group will gradually take over the current governance team with a transition expected by 2031. And then, last but not least, and you have maybe heard of this, each country will also have a digital health authority. Most countries already do have one, by the way. This body will make sure that EHDS rules are put into action locally, I would say. Okay, let's talk about data localization because this is also a very interesting topic. So this is the question where the data must be stored under European health data rules. Well, there are two different sets of rules here. For primary use, so that's when we are talking about patient care. Well, each EU country can decide whether healthcare providers in their territory must store patient data inside the EU. So in this case, the decision is left for member state to decide. So there is, I would say, nothing new under the sky here for primary use. For secondary use, so that's when data can be reused for research, innovation, or public health planning. Well, here the rules, I would say, are more harmonized across the EU. The health data access bodies, so those are actually the national authorities that manage access. Well, they must store the data they process either within the EU or in a country outside the EU, which has been officially recognized as offering adequate protection under GDPR. So this is for data localization. Now let's talk about the territorial scope because we have been receiving a lot of questions around this. Well, if you look at the frequently asked questions from the European Commission, which have been published in March of this year, you will find some answers around this topic. So what are those frequently asked questions saying? Well, they say that EHDS regulation sets out rules for how health data should be accessed in the following way. EHDS applies to health data holders that are established within the European Union. So this includes hospitals, clinics, research institutions, and companies that are based in the EU and that handle health data. So I think the rule is pretty clear. So what about organization that would be outside the EU? Well, if a data holder is established in a third country, so outside the EU, well, then the EHDS does not apply to them unless they have a branch or an office or another form of establishment within the EU. So, for example, a non-EU based sponsor in a clinical trial would only be subject to EHDS if they have an establishment in the EU. So I think that's really important to understand in terms of the territorial scope. So in theory, foreign entities without presence in the EU would not be bound by the same obligation unless they operate within the EU. So now let's talk about EHDS primary use. What does it do?
Thank you, Natalie. As Natalie just mentioned, the EHDS basically creates two buckets that people can work off, and that's the primary use and that's the secondary use. My colleague Nuria is going to talk to you always about the secondary use, and I'm going to be talking to you a little bit about the primary use. Primary use is, as Natalie mentioned, basically what concerns the patient directly. And what does the EHDS regulation do? So the first thing that comes to mind here is that it empowers the individuals, the patients, to actually access and control and share their health data across borders by implementing this system for operability between the various players in the market. There is a staggered approach as regards the timeline, and the first priority set of data has to be made available in March 2029. And that's typical stuff that you see as patient summaries, e-prescriptions, and e-dispensations. And the second group of priority data is the medical images, lab results, and hospital discharge reports. So these have to be available across the union, across the various institutions, which makes it very easy for the patients. At the same time, of course, as usual, our patients require protection, especially their health data. So within the EHDS regulation, they are generally awarded the same standard of protection for the data that they have become used to. They have the right to access and download the health data free of charge. They can add and rectify information, and they can actually control who can access the data. What's very important, they can also opt out of this, and in particular out of the secondary use of data, but it is an opt-out, so by default, their information is opted in. Next slide, please, Natalie. We have additional things that what it does, the EHDS regulation. So not only the patients are concerned, but we have other players who are concerned. What it does, it enables all the HCPs across the market to access the health data of the patients that I just mentioned on the previous slide easily and quickly. And across providers, across borders and systems, it must be available. But the patient has control over it, and patient consent for this access is indeed required. There's also some technical implications already on primary use stage, meaning the EHDS regulation implements a compatible system for sharing of health data. It requires certain electronic health record systems that have to meet certain standards, and it sets up this new space, My Health at EU. In addition, there are some regulatory requirements which are implemented by the EHDS regulation. Member states have to at first designate a national contact body as a point of contact for any organizational and technical concerns. And in addition, the member states must designate digital health authorities, and these will be responsible for implementation and enforcement. My colleague Nuria, I think, is now giving you some more information on secondary use.
Thank you, Katerina. Yes, I'm going to do that. So I'm going to explain what does the Act do regarding the use of data for secondary use. So, however, before I explain how electronic health data might be accessed for secondary use, I'd like to take a step back and consider what is actually secondary use under the Act. The Act sets out specifically the use cases which are permitted uses and the ones that are prohibited, as you can see in the slide. So taking a look at the permitted use cases to start with. So you may process health data for electronic health data for the public interest in the areas of public or occupational health, also for purposes of policy making and regulatory activities to support organizations in the health sector, and also to develop health or care sector statistics. These three first permitted use cases may be carried out by public sector bodies only, or third parties acting on behalf of these public sector bodies. But let's look at the additional use cases which are permitted. You may also use electronic health data for scientific research, including regarding the quality and safety of healthcare, medicinal products or medical devices, including developing products and services, or training, testing, and the evaluation of algorithms, AI systems, and digital health applications. In addition to that, you can also use this data for educational or teaching activities in the health sector and to improve the delivery of care. This is an exhaustive list of permitted uses, but as you can see, it's quite a long list, and it's actually defined. Obviously, I've just provided a summary, but it's just defined quite broadly. In terms of the prohibited activities, these will be activities that which would involve taking detrimental decisions about individuals or discriminating individuals based on their health data. So, for example, in the context of job offers, loan applications, or application of insurance premiums. Advertising and marketing activities are also prohibited, and also the development of harmful products. So, for example, certain drugs, addictive products, or weaponry. And finally, quite a broad concept, which is the prohibition of the use of this data for unethical activities. So it'll be interesting to see how this is going to be defined over time. Let's move to the next slide, please. Thank you. So now that you know what you may and may not do with electronic health data, you may have access to under the Act, let's look at a high level what the Act puts in place in order to allow you such access. So first of all, what the Act does is setting out a common mechanism for accessing electronic health data for secondary use. We will discuss this mechanism later, but in a nutshell, what it does is allows organizations to apply for a permit in order to have access to electronic health data held by others. The Act distinguishes between health data access applications and health data requests. I won't go into detail in relation to these, but these are the different types of applications. The main difference is that the latter, the health data requests, are those requests which only require access to anonymized statistic information rather than full data sets. The creation of this application process doesn't mean that access to health data or partnerships between organizations by direct contractual arrangements may not happen or continue to happen if they are already in place. The second thing I wanted to highlight is that the Act also requires that EU member states designate a health data access body. This will be either a new regulatory body or an existing body who will pick up the tasks of the health data access body. So what are these tasks? So the health data access bodies have certain tasks set out in the Act. And these include, for example, deciding on health data access applications and requests and authorizing such requests by, for example, issuing permits. These bodies also have the task of monitoring and supervising compliance with the requirements of the Act. And also, these health data access bodies will process electronic health data in order to combine, prepare, compile such data, and the anonymization of the data. They are required to take measures to preserve the confidentiality and the IP rights of the data holders. So the data access bodies are not mere post boxes who will take data from one and pass it on to the other. They will actually handle the data and make decisions about its protection. The Act also facilitates the legal justification to process health data in the public interest by providing measures to safeguard the privacy rights of individuals. This is relevant when seeking to set out a legal basis for processing under Article 6 and processing conditions under Article 9 of the GDPR. So as you can see here, and we will see it along our description, there are some crossovers between this new act and the GDPR. You will recall that Article 9 of the GDPR sets out instances where organizations may process special category data in the public interest. This is, however, this requires that such processing is necessary and is carried out on the basis of EU law, which provides suitable measures to safeguard the privacy rights of individuals. So the Act will provide this legal basis in order to rely on such conditions. This is also relevant in relation to processing activities carried out under the legal basis set out in Article 6, which, as you know, will be applied in combination with Article 9 conditions, especially regarding the processing for public interest purposes or for the legitimate interests of the controller or a third party. The last element I wanted to highlight is the right to opt out. And both Katerina and Natalie have briefly mentioned this, especially Katerina, in the context of primary use. But what the Act does in terms of secondary use is provides individuals with a right to opt out from having their personal data used for secondary purposes. Individuals do not have to provide any reason of why they wish to opt out, and this will be managed by a centralized mechanism set out by EU member states. However, this is not an absolute right. There are exceptions to this opt-out right, and there will be instances when even if the individual has opted out, public bodies will be able to process their data for the public interest, for public interest activities such as policy making. And I think I'm handing back over to Katerina now.
Thank you. Finding the unmute button is still a challenge after all those years. Let's briefly talk about who it applies to. In this case, first for primary use. I mentioned before the patients who are in the first step, of course, the individuals who are most concerned by this because their data is now available across borders, across systems, across physicians, institutions, whatever it is, according to the digital health records or e-health records that are now available. And so these are the individuals that are most concerned, at least at the outset. It also brings changes, of course, to the health professionals. This is not only the doctors, but also providers in care homes, nurses, dental practitioners. All of these individuals, they can now access easily the patient's health records via this new platform, My Health at EU. And it should hopefully also facilitate patient care because of the easy access to all the information that is necessary. We have an additional categories of individuals, or rather, in this case, probably companies who are concerned, which are the healthcare providers. Both the healthcare providers and the health professionals are defined in a preceding directive. The healthcare providers in this case are all the companies that are involved in the provision of healthcare. So it's also the hospitals, it's the care homes, and these kind of institutions that contribute to the entire treatment of the individual. The healthcare providers will now be required to enter the data as well, to the data, the health data of the individual into the health records to make it available across borders. And then another group that we haven't really touched upon yet are the companies that provide the systems that are now required to be used. These are the electronic health record systems. They have been in use in many countries, but now, because of this EHDS, there are certain requirements regarding standardization and compatibility. And EHDS Act sets forth certain harmonized software components which must be included in these systems so that these systems can be placed on the market in Europe in a compliant manner. In addition, these system providers must also appoint an EU representative if they're not located in the EU, to have someone who can respond to authorities' requests and similar things directly within Europe. I think for the system providers, it also requires them to update all of their systems that they've distributed in the past, and it may require them to also update certification requirements and ensure that these harmonized software components are included in all of the systems that they distribute. And I think more importantly, we have quite a few players in the secondary use, which Nuria is going to allude to.
Thank you, Katerina. So, as you say, I'm now going to look at the main actors in the context of the processing of electronic health data for secondary purposes. So these, in a nutshell, these are the health data user, the health data access body, and the health data holder. So this slide exemplifies at a high level the role of each of these players in the process whereby users may gain access to electronic health data in order to use them for secondary purposes. And as you can see, users will submit an application to the data access body. The data access body will consider the application and either reject it or issue a permit. And then the electronic health data will be requested by the data access body from the health data holder in order to make it available to the user. There is an alternative simplified process to the one described in this slide, which applies when the data holder gains the status of trusted data holder. If that is the case, the data holder will be more involved in the assessment and in the assessment of the application and in the provision of the data to the user. We already know from earlier in the presentation what a health data access body is. So I'm not going to stop here. We know what it is, what they do, and what are their tasks under the Act. In terms of the health data users, they are defined as a natural legal person, including in the public sector, who are granted access to electronic health data for secondary use purposes pursuant to a permit. So as you can see, it is a broad definition. And in a minute, when we go to the next slide, I'll talk a bit more about the data holder in a bit more detail. But before we do that, I wanted to highlight again some GDPR crossover. So the Act explicitly sets out that the health data holder, when making electronic data available, will be a controller of such personal data. So At the same time, the health data access body shall be deemed a controller of the electronic health data. So we can see many organizations acting as controllers. We can see from the FAQs that the Commission has issued that they might act sometimes as joint controllers. So we'll need to look into this in a bit more detail and how this pans out. Furthermore, the Act also sets out that the health data access body will act as a processor of the user when it processes health electronic data pursuant to the data to a data permit, or when it's processing the data under a data request. So as we can see, the Act is already helpfully defining the roles of the different parties under the GDPR. And what we know is that these different roles and these different data flows between the organizations will require certain terms between the different parties before they share data with each other. So let's move on to the next slide to assess the role of the health data holder under the Act in a bit more detail. So the definition of health data holder is a long one. So the one on the slide is actually not the definition. So it's a summary that I've put together. So by all means, do have a look at the definition in the Act. The reason why it's important to identify whether you are a data holder or not is because if you are, you will be required under the Act to provide access to your electronic health data sets. So who are data holders? So they are any person, private or public or private in the health sector, also developers of products or services for healthcare, for the healthcare sector, developers or manufacturers of wellness applications, researchers and mortality registers, so either of these categories who do one of two things. So what do they need to do to fall under this category? So they either need to process electronic health data for the provision of healthcare, public health, research, innovation, policymaking, statistics, or patient safety, or they have the ability to make available non-personal electronic data because they are in control of that particular system. So as you can see, it is quite a broad definition that I think may apply to many organizations that are actors in the health space. In a bit more detail, the following categories of data holders are exempt from the data holder obligations. And these are natural persons, including individual researchers, and also microenterprises as defined under European law. And these are enterprises employing fewer than 10 people and whose annual turnover or annual balance sheet total is 2 million euros or lower. So these may apply and provide some relief to startups in the health sector and small organizations. Another point that's interesting is that the Act sets out that under EU member state law, the duties of data holders may be allocated to another organization. So, for example, health data intermediation entities. So I guess we will have to see in practice whether this takes place or not. And the last point is about trusted data holders. As I explained earlier, if an organization is characterized as a trusted data holder, the process whereby data is handled and handed over to the users will be more streamlined. So an organization may be awarded the status of trusted data holder if the health data access bodies believe that they're able to provide access to health data through a secure processing environment, if they have the expertise to assess the data access application form and application and requests, and if they provide the necessary guarantees to ensure compliance with regulation. If that's the case, they will be awarded the status of data holders, and there will be a register, public register of trusted data holders that will be publicly available. As we have seen earlier, if you qualify as a data holder, you will be more involved in the review of the data access application and in the provision of the data to the user. So in practice, it means that you can retain more control of your data. So I think that's an important strategic consideration for organizations as to whether they would like to apply or be considered to be a trusted data holder. I'm handing now back over to Katerina, who will tell you about why is all of this relevant to you and how it may affect your business.
Thank you, Nuria. Why are we even talking about this, right? For the secondary use, I think it's quite obvious, and Nuria is going to give you more detail on this. Primary use, let me start on the bottom right. The patients, we're all patients, I guess. So this also goes out to all of us. Ensure you know your rights. But this can be done, for instance, because the physicians, the HPs, but also the healthcare providers are now required to also provide sufficient information to the patients so that they do know about their rights. This brings the connection to the top left box where I talk about the health professionals, the physicians in particular. They do have to inform their patients about this EHDS and how their data is being processed. But in addition, these health professionals also have to ensure that their electronic health record systems are now compatible with the requirements. I briefly touched upon it a moment ago, talking about these harmonized software components and conformity assessments and similar. And so these HPs all have to ensure that their systems do not comply. How can they do that? Because the system providers, they now have to ensure that their systems, the EHR systems, are indeed subject to the conformity assessment and can ensure compatibility of the system with the market. In addition, we already touched upon them, the healthcare providers. I mentioned before that they now have to actually register the health data. That is their most important task. When they now treat patients in the healthcare center, they have to register the electronic health data so that it does end up in the EHR system and can be used in that European health data space. Over to Nuria, who has the exciting relevance of the secondary use for you.
Thank you. Thank you, Katerina. Very exciting. Before I go and continue with the presentation and talk to the slide, which you can see now, I just wanted to pick up a question that has been asked during the earlier part of the presentation, which is about whether the rules regarding permitted and prohibited secondary purposes apply to health information generally, or only information accessed through the centralized EHDS process. And just briefly, this applies to any electronic health data which is accessed via the permit process that I've explained earlier. So what happens, and I haven't provided a lot of detail onto this, and in our next webinar, we will get into more detail, is that when you submit your application, you have to very clearly explain what you would like to process the data for. And when the data access body reviews your application, they have to be convinced that it will be within these permitted uses. So that's where these prohibited and permitted uses becomes relevant. So moving on now, as Katerina was saying, to something that could be exciting or could be seen as an opportunity. So I guess that the first thing to say is that in recent years, organizations in the health sector have been hit by numerous new digital regulations in the EU. And you know, there might be a perception, and not an unfair one probably, that this new act is yet another one to add more pressure to everyone's you know, stretched internal resources and compliance and legal teams and security teams and so on. So, however, my part of the presentation is to explain that also this is an opportunity for organizations to access information for its own secondary purposes and use. Looking at the right-hand side, we'll go through first the obligations of the data holder. And these may feel cumbersome. And as you can see, I've sort of done a high-level comparison between, you know, is this a burden, is this an opportunity, and the different roles of the data holders and the users. But actually, what's important to remember is that any data holder can also be a user and vice versa. So if you are a data holder and feeling the pain of having to comply with some of these, you may also benefit from having access to additional information. So in a nutshell, what data holders have to do is provide a description of the data sets that they hold to data access bodies. And these will, information will be compiled and put together in a national data set catalog. In order to ensure the protection of their IP rights, the data holder may need to enter into a contract with the data users who will have access to the data. So that's another activity, that's another thing for data holders to prepare for. In addition to this, data holders will have to provide access to electronic health data or make the data available to health data access bodies in accordance with the data permit. While the Act sets out mechanisms to protect IP rights and trademarks, these new obligations may impact the strategic decisions of data holders regarding the data they process and whether there might be a perception that there is some degree, that to some degree, the data holders may lose the control over the data. In terms of IP rights and trade secrets, as I said, there are proactive steps that the data holders may take to protect them, and major measures taken to protect them are set out by the data access bodies. In terms of data users, they will have the opportunity to access data sets, but this is not a free-for-all. This is subject to conditions. So the data users may be subject to many requirements, including that they can only process the electronic health data only as set out under the permit, and perhaps for a certain period of time and just for a certain purpose. They cannot share the electronic health data they have access to with third parties unless this is explicitly mentioned in the permit. They cannot try to re-identify the natural individuals to whom the data is about. So say, for example, if they have been given access to an anonymized data set or a pseudonymized data set, they're not allowed to try to re-identify the individuals. The data users also have to make public the results or outputs of secondary use within 18 months of the completion of their activities, and also inform the health data access body of any significant findings. The data users will also have to assist public access bodies to make the information available on the health data access bodies websites. And they might also be required to pay a fee when they gain access to the information. So as you can see, there are obligations and opportunities and burdens, perhaps, on both sides. And what this gives us is a picture of a number of obligations and strategic considerations that organizations may need to carry out. So as we can see, strategic considerations and also the development of new internal policies and procedures for the adjustment or the adjustment of existing ones regarding data handling and data sharing. Organizations will also be ensuring that access of the data is done securely. And this will mean the requirement. This will require the commitment of resources and the involvement of many functions within the business. And if things go wrong, you may be at the receiving end of some regulatory activities. So on that happy note, I now pass on to Natalie, who will explain a bit more about this.
So let's talk about sanctions now. So we don't want to be mean, but we thought it was relevant to bring you some information around this topic as well, to understand the possible consequence in case of non-compliance. So the EHDS contains a dedicated enforcement sanctions, and you will see that the enforcement is primarily attributed to each member state's health data access body. So this is a bit comparable to GDPR, where data protection authorities take care of the enforcement. Well, in this case, it's the member state's health data access body who will monitor the compliance by data holders and data users and may request additional information to them. For your information, individuals also have a right to lodge a complaint with this data access body. So, in particular, the health data access body has the power to revoke a health data user's permit and exclude a data user from the EHDS, and this up to 5 years. So this is quite a big consequence, I think, for those data users that they would have their permit revoked. The health data access body can also fine a data holder who would refuse to share the data, and this with periodic penalty payments. The amount of those fines will be established by national law. And in case of repeated breach, well, then the health data access body can decide to exclude the data holder from benefiting to the access to EHDS data, while being required to still share data as a data holder. So this is also quite a strict consequence. In addition to this, the health data access body can also impose administrative fine on data users, to a lesser extent also to data holders. So if you look at the, I would say the fining terminology in EHDS, well, you will find it's quite similar to the one of GDPR, and the potential fines are also quite similar. So you can see that for minor infringement, you will have fine up to 10 million euros, and in case of undertakings, 2% of the total worldwide annual turnover of the preceding financial year. And for the other stronger violations, there we have fines up to 20 million euros, and in case of an undertaking, 4% of the total worldwide annual turnover. So this is quite significant. As an exception to what I just said, data protection authorities will also play a role in this because they will be responsible for enforcing the EHDS opt-out of individual. So this has been mentioned that individuals have this opt-out right. Well, it's the DPAs who will be in charge of enforcing this. And finally, individuals also have the right to receive compensation for material and non-material damages suffered as a result of an infringement of the EHDS. So this is, I would say, the sanctions in a nutshell. Now let's talk about the timeline. Well, you'll see the timeline is a little bit complicated. The EHDS regulation will be implemented in several phases. Why? Because there's still a lot of preparatory work that needs to be done before we can actually operationalize it. So we have a first phase, and this is basically now until 2027. This is, I would say, the secondary legislative phase. Why? Because we are still waiting for implementing and delegating acts. Then there will still be some time for member states to get prepared. So this will take place until 2029. So if you look at the key provision, whether they are related to primary or secondary use, you will see that from 4 years entry into force, we have the first group of priority categories. And then as of 6 years entry into force, so this means by March 2031, then it will be the second categories of data who will be implemented. So practically, what does this mean? Because it's, as I said, it's quite complicated. Well, for patients, when we talk about primary use, patient will be able to use this system as of March 2029, as I said, for the first group of priority categories. So this is, for instance, patient summaries and prescriptions. And for the other data, so for instance, medical imaging, test results, and discharge report, the system for primary use will be in place in March 2031. So we already mentioned manufacturers of health record system. Well, for them, it's a bit comparable. So manufacturers must comply with the common specification for those systems. And the phase date, they align with the categories of data becoming accessible. So first or second category. For the data holders now, so hospitals, labs, insurers, well, again, same system. So either by March 2029 or 2031, they will be required to submit their data set descriptions. So again, depending on the type of data. For health data users, so for secondary use, again, it's March 2029 or March 2031. So as you can see, it's really a phased approach. Now, for member states, they have to be ready by March 2027. Okay, so by this date, they have to establish their national digital health authority. And this is to ensure the cross-border data exchange. So indeed, this transition period, it seems quite long at first sight, but there's still, as I said, a lot of work to do to get ready for all the stakeholders involved. And that's the reason why it will take more time. So last but not least, as I already mentioned, we are still waiting for the implementing acts, okay? And this is the responsibility of the Commission to adopt them by March 2027. They will be related to mainly technical details, so technical specification, for instance, related to the exchange format, but also the detailed requirements for the manufacturers, the security measures around the processing, and so forth. So Nuria, what about the next steps?
Before I go on to the next steps, thank you, Natalie. There is a question which is in relation to the GDPR style penalties that you've explained a couple of slides ago. So I was wondering whether you could pick this up now. So the question is whether they're applicable to data users, data holders, or both.
Yeah, it's to both.
Mm-hmm. And then the follow-up question is whether they are already predefined or there is room for member states to still change the penalties.
No, I mean, it's already defined, but it's for the additional implementing of this, but it's already defined in the EHDS.
Great. Thank you. So I'm conscious of time. We only have a few more minutes. Thank you for the questions. So in terms of wrapping up, first of all, thank you so much for joining us this afternoon. It's been a pleasure to discuss with you a sort of an overview of what it is, a really fascinating and complex piece of legislation that's coming, across our desks, and we're starting to work on it. So I guess the next question is for you, what now? What are your next steps? And I think, the fact that you're here, that's your first step, obviously. So thank you for joining us. And I think that the first step would be carry out an assessment of the material scope of application. Does it apply to you? Are you one of those actors that we have talked about earlier? Are you handling EU electronic health records, either yourself as a public body or as a service provider, a technology provider of these healthcare providers, and so on and so forth? So there will be many actors that will be caught. In addition to the material scope, you should also consider the territorial scope. And as Natalie was saying earlier, this is not tightly defined in the law, but there is already guidance. And global organizations with establishments in Europe are likely to be caught. But I think we'll need to see on a case-by-case basis whether this is the case or not. And then, as with all new regulation, is go and identify internally who are the relevant stakeholders across the organization, so that you can put together a team of advocates for these, raise some internal awareness, and ultimately get some senior buy-in and budget for your future compliance activities, which, even though they seem far away in the horizon, as Natalie was saying, this is a staggered implementation. So work will need to start sooner rather than later. And as we said earlier, we're already working with some clients on this who are starting to look at the applicability assessment. So if you have any questions or you would like to discuss any of these with us, don't hesitate to contact us. And all that remains to be said is thank you so much for joining us this afternoon. You have our contact details in the slides. You will receive a recording of the webinar directly in the next few days. And thank you very much for joining. Have a good afternoon. Take care. Thanks. Bye.
Thanks. Bye.